Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to provide an update on the story of Cedar the goat. So if you haven't been following this story, what happened is this girl raised a goat through the 4-H program. And as sometimes happens, she fell in love with this goat. She called it Cedar. She spent all of her time with this goat. She loved this goat. And the problem is that the 4-H program involves the goat gets raised and then it goes to auction. The ultimate destination of this goat was to be eaten. So she did not like this. She didn't really want this. And this goat was sold at auction for about $900. Now, here's the thing, is that this girl and her parents say, whoa, 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 we want to back out of this sale. We're not cool with this. And California law actually seems to give them the power to say, we don't want to back out on this. There's some wrinkles and some complexity, but I'm just summing up here. So they said, we don't want to go through with this sale. And they didn't actually take any money. There was $900, but they didn't take the money. The money was ultimately supposed to go to them minus an auction fee. And they even said, listen, we'll pay the auction fee. We'll make sure that 4-H is covered. They get their money. We really don't want Cedar the goat to get killed. And they had plans for, we'll put Cedar in a sort of a place where she'll live out her life and all of that. Now, 4-H got mad. They didn't like that this goat was not going to get killed. So they decided to contact the police and they said, we need you to get this goat. Now, the actual buyer of the goat was a politician and he said, I'm cool. Give the girl her goat. Let her have the goat. He didn't want the goat killed either. The only people in this who really wanted to kill the goat was the 4-H. So all of this is, you can already see that there's bad ideas written all over this, but the police go and they go looking for this goat. They've got a warrant for the goat. And unfortunately, they don't find the goat where unfortunately for the police, they don't find the goat where they expected to find the goat. But they get word that the goat might be somewhere else, and they go seize the goat in a place where they don't have a warrant to get the goat. So, yeah. As a result of this, the goat is returned to the 4-H and is ultimately killed, which breaks the heart of this little girl. Okay, so now you're caught up. This girl and her parents sued a whole bunch of people for basically, hey, you had no right to do this. And one of the groups was the police. She said, you had no grounds to take this goat. You took our goat, you gave it to the 4-H, you didn't have any business doing so. In doing so, you violated the law. Okay, now that case has now been settled, and there is a little bit of victory, a little bit of justice for Cedar the goat. Let's have a look at this. Now, I did cover this on a live, but I've had a lot of people message me saying, Runkle, when are you going to cover Cedar the goat? So I figured maybe we should go through the settlement in some detail and talk about it. Okay. So this is from the United States District Court for the Eastern District of California. It is Jessica Long et al. And Jerry Fernandez et al. Now, this is an order granting motion to approve settlement of a minor's claim. Why do they have to approve settlement? Well, because it's a minor is involved in this. And the court wants to make sure that minors are not being, that their rights aren't being trampled on. That we don't have a lawyer who's basically walking away with the entire settlement. You don't have various other abusive practices. So because of that, we get to sort of go through all this, and we're going to get a little bit of detail that we might not otherwise get. Okay. So on September 27th, 2024, plaintiff E.L., that's the child, by and through her mother and guardian ad litem, plaintiff Jessica Long, filed a motion for an order approving a proposed minor's compromise settling her claims brought against certain defendants in this action. This is against the police, the government actors here. Defendants have not filed any opposition to the pending motion. I don't think that they'd really have any reason to care on this one. For the reasons discussed below, the court will grant the pending unopposed motion. Okay. The defendants probably don't have much reason to spike their own settlement. And if you're wondering why was this settled, the police seizing a goat without a warrant to do so puts them into very clearly screwed up behavior. Like they're in screwed up town. If you want to get the goat, you got to have a warrant for the goat. And the warrant is specific. You can't just go looking for the goat wherever it is. You got to search specific places. They were outside of their authority. And once they're outside of their authority, well, then you don't get the goat. Background. Plaintiff EL is an 11-year-old girl, but she was 9 years old at the time of the events giving rise to this action. In their operative's second amended complaint, plaintiffs alleges that defendant improperly seized and killed a goat that plaintiffs put up for sale at a 4-H auction in June 2022. Plaintiffs filed their SAC second amended complaint on October 12, 2023. In their complaint, plaintiffs assert the following 6 claims against defendants Jerry Fernandez, Jacob Duncan, Jeremy Ashby, County of Shasta, and Shasta County Sheriff's Department, collectively the county defendants. 1. Unreasonable search and seizure in violation of the Fourth Amendment against defendants Ashby, Fernandez, and Duncan. So basically, you didn't have the authority to take this goat. So you don't get the goat. Yeah. 2, the get the goat thing, I keep feeling like it's sort of hitching in my brain in an odd way. So 2, denial of due process in violation of the 14th Amendment against defendants Ashby, Fernandez, and Duncan, i.e. you were supposed to get a warrant. You didn't. You were supposed to also hold on to the goat when you seized the goat because it was disputed property. You know, there was an argument over what should be done with the goat. And once you've got that argument, you can't just say, oh, well, we're just going to give the goat back to the 4-H, because they actually needed to hold on to the goat to say, hey, whose goat is this, ultimately? And because they didn't do that, it prevented EL and so forth from actually being able to contest that in order to maybe have the goat returned to them. So 3, unreasonable search and seizure in violation of the California Constitution against defendants Fernandez, Duncan, Shasta County, and Shasta County Sheriff Department. 4, denial of due process in violation of the California Constitution against same people. Conversion against defendants Fernandez, Duncan, Shasta County, and Shasta County Sheriff's Department. So conversion is you took the goat. It wasn't your goat. You made that goat yours through some process, and that was unlawful. Basically, conversion is kind of the tort version of theft-ish. So, yeah. Essentially, conversion is that was not your goat. You couldn't take the goat. Bad. So, and negligence against everybody. Okay. All parties in this action attended a mandatory court-supervised settlement conference before Judge Soo Kim on August 5th, 2024. Plaintiffs and the county defendants continued private negotiations after the mandatory settlement conference. I imagine the settlement conference involved the judge looking over at the sheriffs and going, so, you're gonna write a big number on this one, and it'll be up to you guys to figure out how much it is, but you screwed up. And you clearly screwed up. So let's just talk about how big that number has to be. So on August 28th, 2024, based upon those continuing negotiations, plaintiffs and the county defendants filed a notice of settlement resolving only plaintiffs' claims brought against the county defendants. What do they mean here? Well, it means that there's still a lawsuit ongoing with the 4-H club, but this is just resolving the police aspects. Because the police are really in a different position than the 4-H club. There's different issues, there's all of that, and they'll have their own lawyers and so forth. So, yeah. So on September 27th, they filed the pending motion. And this motion is just to say, court, here's our proposed settlement. Please approve of this. Because there's a minor involved, the court needs to say, is this settlement fair to the minor? Or is this minor being screwed over in some fashion? And, I mean, that's a good thing, right? This girl's already been screwed over with respect to Cedar the goat. I kind of like that the court is looking out for her. This is a good thing. Okay. Legal standard. This court has a duty to protect the interests of minors participating in litigation before it. To carry out this duty, the court must conduct its own inquiry to determine whether the settlement serves the best interests of the minor. So, here's the problem. If you are on YouTube or any of these things, you will see like parent videos where they do things with their kid. And often you go, is this really good for the kid or is this just good for the parents? And often the kids get none of the money. There have been issues like that with child actors in Hollywood and so forth. And the court is trying to make sure that they don't do that kind of abusive behavior with kids in court. So, a court must independently investigate and evaluate any compromise or settlement of a minor's claims to assure itself that the minor's interests are protected, even if the settlement has been recommended or negotiated by the minor's parent or guardian ad litem. So, in examining the fairness of a settlement of a minor's federal claims, the Ninth Circuit has held that a district court's inquiry should focus solely on whether the net amount distributed to each minor plaintiff in the settlement is fair and reasonable in light of the facts of the case, the minor's specific claim, and recovery in similar cases. So essentially this comes down to, is the kid getting enough money? And I mean, that's really what the law deals with a lot of the time, is money. So how much is the kid getting? Is it fair? Are they getting screwed out of it? Out of money they should be having. So, where a settlement involves state law claims, federal courts generally are guided by state law. And they note federal courts generally require that claims by minors be settled in accordance with applicable state law. California law requires court approval of the fairness in terms of the settlement. Under California law, a settlement for a minor and attorney's fees to represent a minor must be approved by the court. And this is another wrinkle here, which is that this case was taken on by a legal group that does essentially animal law activism stuff. And normally me and them are probably not going to be the kinds of people who get along. But in this case, where they're acting against like government overreach, and there's sort of a clear there's a really clear sympathetic figure and some clearly less sympathetic figures. Now, some people have said, listen, the 4-H club has to make sure that kids understand farming and all of that. The problem is the 4-H club also needs to follow the law, and if they're outside the law, that's a problem. So, but anyway, they stepped in to assist here, and it's fair they get a cut of the money, right? So, all right, reasonable expenses and court costs to be paid out of the settlement also must be approved by the court. Finally, the local rules of this court require the parties to make disclosures regarding the minors involved, the nature of the controversy, the manner in which the compromise was determined, and whether a conflict of interest may exist between the minor and the minor's attorney. So all of this is stuff the court's going to consider. Analysis. In petition for a minor's compromise, courts typically consider such information as the relative worth of the settlement amount, the circumstances of the settlement. So relative worth is just how much money's in the pot. Circumstances is why is there money in the pot? How did that money come to be there? Why is this being settled? Are they settling it for too little? Are they getting a windfall? What's going on here? Counsel's explanation of their views and experiences in litigating these types of actions. Counsel may get more money if they are very experienced. They may get less money if they're not so experienced. These things matter. And other similar compromises that have been approved by the courts. So, past precedent. Courts are all about past precedent. Like what happened before, we're going to do the same thing again. All right. So they cite some case law. We're going to skip over the sort of case law citations, but they say, having considered the unopposed motion for approval of the minor's compromise in this case, the undersigned concludes that the settlement agreement is reasonable and in plaintiff EL's, that's again the child's, best interests. The proposed settlement agreement provides that plaintiff EL will receive $65,000 of the total $300,000 amount offered to settle plaintiff's claims brought against the county defendants. Now, if you are watching, you are probably going, wait, what? This girl's only getting 65 grand out of the 300 grand? Yes, hold on before you freak out, because this is actually probably reasonable, and we'll talk about why. So the court finds this amount to be reasonable under the circumstances. As an initial matter, plaintiffs provide the information required by Local Rule 202, namely plaintiff EL's age and sex, I don't know why sex really matters here, but okay. The nature of the causes of action to be settled, the facts out of which the cause of action arose, the manner in which the settlement amount was determined, and details regarding the terms of employment of plaintiff attorneys in this action. I don't get why it would matter that EL is a girl versus a little boy. Like, okay, either way, it's a 9-year-old kid, right? But okay, they're considering that. I don't think they really turn much on it, but it's odd that it's in there. So furthermore, the proposed settlement agreement is similar to agreements approved in other similar circumstances. Now, they're going to break down some of the interesting aspects here. Plaintiffs note the lack of cases in which defendants captured but did not kill a companion animal, and in which that purported companion animal was a goat and not, for instance, a dog. What does this mean? Well, most of the case law is going to be about police officers shooting people's dogs, right? Because that happens a lot. Shooting people's goat is not super common, but in this case also the sheriffs didn't personally go, oh my god, it's a dangerous goat, blam, blam, blam. They said, oh, well, we're seizing this goat, and they delivered it to the 4-H, and then the 4-H killed the goat. So is that intervening step of delivery to somebody else who killed it, is that something that protects them? What does that mean? So consequently, plaintiffs analogize generally to cases where law enforcement defendants killed the subject companion animal. And usually that's going to be a dog, right? So, and they cite to a case that approved an $85,000 settlement agreement providing $8,000 to one minor child and $7,500 to another minor child, where law enforcement defendants shot and killed a family's dog. So plaintiffs note that, given the unusual circumstances that give rise to this action, they were unable to identify factually similar actions. It's just, this is such a weird case, right? It's an unusual case. So nonetheless, plaintiffs have provided references to a few cases, and the court finds that those cases are sufficiently similar to this one to be useful points of comparison with regards to settlement amounts. Here, as noted, plaintiffs allege that the county defendants merely turned over Cedar to other defendants and did not themselves kill the subject animal. The thing is they knew those people were going to kill the subject animal, right? They knew they were going to kill Cedar the goat. So the court notes that plaintiffs argue that the brunt of emotional damages the child suffered relate to Cedar's death, for which the non-settling defendants are responsible. I kind of think both are responsible, but fair, okay. They also look at another case. That case approved a almost almost $1 million settlement agreement where two minors received $15,000 each because the medical records attached to the pending applications reflect that the plaintiffs suffered only minor, non-permanent injuries in the collision. So the court concludes that $65,000 is sufficiently similar to minors' compromises that have been approved in similar cases involving law enforcement defendants and companion animals. It actually looks like it's higher than in most of those cases, but the court is not going to object if the kids are getting more money than the average bear, right? The court's worried if the kids are getting less money, not more money. If more money is good, the court is only looking out for the kid's interests here. So, hey, there's similar cases where a kid got $15,000. This kid's getting $65,000. Court's going to be A-okay with that. 100% every time and twice on Sunday. So, the court further finds that the amount deducted from the child's recovery for attorney's fees is reasonable here. Of the $100,000, the proposed settlement agreement that will be paid to the child, 35% will go towards attorney's fees. So really, her $65,000 is $100,000 minus what her lawyers are taking. Okay, now her lawyers, that means, are taking $35,000 of that $100,000. Is that reasonable? I think that's actually a bargain for, you couldn't have hired the lawyers to do that work for the money that was paid. Just full stop. Any additional attorney compensation, including any costs and expenses, will be paid from plaintiff Long's $200,000. That's the mom. Mom is getting 200 grand. And any additional money, so the lawyers are getting more than 35,000, but they're getting the rest of it from mom. Okay. Now they note in the Eastern District of California, 25% of the recovery is a reasonable benchmark for attorney's fees in contingency cases involving minor state law claims. But wait, you're saying they're paying 35%. Why do they get 35%, not 25%? That's an extra 10 grand for this kid. Well, the court's going to explain. And I think the court's reasoning is actually pretty solid here. Notably here, plaintiff's counsel undertook representation entirely on a contingency basis, i.e., if they lost, there was no money to be made for themselves. Assert that they spent nearly 500 hours on the case. That's a lot of hours. Fronted all costs, so nothing was paid by Jessica Long, the mom, or the child, and had specialized knowledge in the subfield of animal law. I mentioned before that if you have special expertise, that the court's going to look at that. This is the court saying they have special expertise that not everyone has. And so, yeah, basically that extra 10% here is being approved because they spent a ton of time on this and they stepped up, they paid all the costs, they did all of this stuff. There is a parallel to like the taking care of Maya case here. And essentially the court is going to be a little more generous or a little more, in situations where the lawyers are kind of stepping in and just, they're playing hero here, kind of, right? So, I'm sure the 4-H club and the sheriffs don't think so, but to the little girl, they were absolutely playing hero. So accordingly, and particularly in light of plaintiff's counsel's seeming ability to generate a recovery far exceeding the average award in arguably similar cases, this is the court saying, so you know how those other cases gave like $7,500 and like $15,000? Counsel here managed to land so much money, all the money. And so we're going to give them a break here. We're going to give okay, sure, they're taking $3,500, but I'm sure that the girl here is much happier with $65,000 than she would be with like $15,000 minus 25%, right? Lawyers are infamously bad at math, but I'm pretty sure that $65,000 is bigger than $15,000 minus 25%. I'm not going to run through the numbers here. I'm not going to break out my calculator. I just feel confident in that numbering. So, all right. So they cite to some case law. They refer to a case where a 50% contingency fee was paid. Okay. This is less than 50%. They also cite to one of a 40% contingency fee. So it appears that the lawyers for the girl here and the mom are taking less of a contingency than in some similar parallel cases. All right. And they note here as well that each minor plaintiff's, or they say that the inquiry should focus solely on whether the net amount distributed to each minor plaintiff in the settlement is fair and reasonable when considering the settlement of minors' federal claims. So, conclusion. The court agrees with all of this, but there are some restrictions. The county defendants shall pay $65,000 for the benefit of EL to the Long Family Settlement Trust established by the Eastern Point Trust Account Company, and no withdrawal shall be made from the trust account except by plaintiff EL when she reaches the age of 18 and is granted access to the trust account at that time. So all of this money, that money is going into a trust for her when she becomes an adult. It doesn't even say that the parents can pull money out of it for her reasonable expenses. That is just hers. So when she turns 18, hopefully that's like an entire college education there. That's like an entire, well, it's not a house, it's a down payment on a house. There's all sorts of things. So Cedar the goat, In dying, Cedar the goat has sort of done a lot to provide for this girl. It's kind of a tragic story, but this yeah, it's not gonna I don't think it's gonna, fix the emotional injury there, but it's gonna do a lot to help this girl out when she becomes an adult. So yeah, this is a settlement that is very much a good thing for this girl, and it does provide some justice for the whole Cedar the goat situation. I know there's a lot of people who were really upset about this case, and I was one of them, because I get the role of the 4-H club and all of that, but they've got to follow the law, and in this case they didn't. And similarly, although this isn't about the 4-H club, this particular settlement, this is a bit just about the sheriffs, and the sheriffs were definitely out of line. If the sheriffs had gotten a warrant to get the goat, okay. And if the sheriffs had then gotten the goat and preserved the goat, they take the goat to a special secure goat facility. I don't think they have one, but they'd have to figure one out in order that they could hold on to the goat while everything was being resolved and let it be figured out who owns this goat, who should properly get the goat back. Because the court might have said, after all of that, they might have said, goat belongs to the little girl. Give her her goat. You don't get the goat. The sheriffs prevented the girl and her mom from being able to have their day in court, because you can't go to court and ask them to, resurrect the goat. The court does not have that power. And the police should not be making decisions that essentially preempt the entire court case when they don't have the authority to do so. That's why they're paying out here. And quite frankly, a large reason for why they're paying out this big settlement. It's clear that they were going to lose this one, right? That's where this was going. And a jury might have hammered them even harder, because the circumstances of this are really sympathetic. But the other issue here is that a lot of media pressure was on the Cedar the goat situation. So you guys watching this helped this girl get justice, justice for Cedar the goat. It does kind of bring a tear to my eye, and I am happy with this result. I think it's a good result, and we'll see. There might be another settlement upcoming with the 4-H club. We'll see where that goes. If I was them, I would be looking at this and I would be going, oh, that's not good. So yeah, let me know what you think. I know last time there were some people who thought I was out to lunch here, because they were like, listen, the 4-H club's got to put their foot down. But this isn't the 4-H club. This is the sheriffs. This is the police. This is the government officers who stepped out of line and stepped themselves into a major cash payout. So let me know what you think. There might still be a bunch of people going, Runkle, you're crazy, and that's fine. I enjoy reading those too, so long as you're, polite. There's sometimes people who are less polite, but I really do appreciate the people who are like, hey, you're wrong about this, because sometimes I think about it and I go, oh, didn't think of that. So let me know. I really, on these ones that sort of get that kind of back and forth, I do want to see that. So I also want to thank my Patreon supporters. I'm going to have a link to that in the description below. At the $50 level, Bottle Shock and Oz, Canada's National Firearms Association, the Canadian Shooting Sports Association, the CCFR, PJs Forever, CMP, Cielo, and Purple Dragonair. And at the $20 level, Mark, Lindsay Metcalf, Larry Kalniak, Kyle Fox, Drunkle of the Baileys, Cameron Johnson, Andrew Elsich, Marvin, and Dorky Dane. Thank you as well to my $10 supporters who will be in the crawl immediately following. Thank you for watching. Hope this has armed you with knowledge. See you next time.